Talking Gavel is for educational purposes only. While Chris and Jamie always try to provide accurate information, the law is like what I'm willing to eat. It's always changing. This podcast is not legal advice and does not create an attorney-client relationship, but they promised me it would be a lot of fun. For you. Can I get my candy now?
So the kids are alright. So the kids are alright.
Hello, everyone, and welcome to Chalk and Gavel, where we explore how the law shapes education one case at a time. I'm Chris Thomas.
And I'm Jamie Cudlitz. Thanks for joining us. Today, we're going to cover a big Supreme Court case about how involved schools can be in regulating off-campus student speech. This is the case of Brandy Levy and her profanity-filled Snapchat messages versus the Mahanoy Area School District. And sorry, folks, but we're going to keep our clean podcast rating on this one.
Something Brandy Levy was not as concerned about.
So the kids are alright. So the kids are alright.
All right, everybody. Welcome to episode 3. We're going to kick it off with a bell ringer before we get into our Brandy Levy versus Mahanoy Area School District. So, Chris, what's our bell ringer today?
So this is a fun one. It comes to us from Oklahoma, and it's an ongoing legal dispute. So recently, the Republican Attorney General of Oklahoma, Gentner Drummond, filed a lawsuit against the state's charter school board to prevent the charter school board from authorizing the state's and the nation's first religious public charter school. And this is really interesting. So it would be the first religious charter school in the nation. And as we talked about in our first episode, there's some really big questions about whether charter schools are public actors under the Constitution. And under our Constitution, we've got these two religion clauses. In the First Amendment, there's the free exercise clause, but there's also the establishment clause, which says that essentially the state can't establish or make laws respecting an establishment of religion. And so here we've got this Republican AG suing the Republican-dominated charter school board to prevent the creation of this virtual religious charter school, which is just really interesting because typically, Oklahoma, you would think everyone would be kind of on the same page, but that's obviously not the case.
So this is really fascinating. So essentially, what we talked about in our first episode about how at least the Fourth Circuit considers charter schools to be state actors. If that logic is applied elsewhere, like in Oklahoma, and this charter school is approved, this would be the first religious public school in the United States.
Correct. Yes. And we've been fighting about the role of religion and how to incorporate religion within public schools and kind of what the lines are. That's been an ongoing fight in the law for, centuries, pretty much as long as there's been public schools.
Yeah, right.
This adds a new wrinkle to that because this is a charter school. So, whether or not it's a public school at all is an open question. Oklahoma is not in the Fourth Circuit, so
right.
They'd have to answer that question. But yeah, it's interesting. And the school has actually already been approved. So the Oklahoma Statewide Virtual Charter School Board voted in June 3-2 to approve the Catholic Archdiocese application to establish this online public charter. The thing that the AG Drummond is suing to prevent is they signed a contract to essentially allow St. Isidore of Seville's Catholic Virtual Charter School, which is sponsored by the Archdiocese of Oklahoma City. I apologize if I pronounced any of those words wrong. But so the AG sued in state court, actually, to stop this because his argument is that it violates both the U.S. Constitution as well as Oklahoma's constitutional provision that prohibits the use of public money or property from being used either indirectly or directly to benefit any church or system of religion. And so we've seen a lot of litigation over clauses like this in the Supreme Court, which is kind of the interplay between the free expression clause and the establishment clause of the U.S. Constitution. And this is really kind of getting at that question of how much play in the joints is there between the establishment clause and the free exercise clause. Because on one side, the argument is that this is a free exercise of the school sponsor's religious expression, it's the free exercise of parents to choose to send their kids to a religious institution. On the other side, the Establishment Clause argument is essentially that these schools are actively promoting religion. They are evangelizing.
Right. Proselytizing, right?
All of these words I can't say. And that would be a violation of the Establishment Clause if this is a public school, because public schools can't essentially promote one religion over another or teach religion as fact, right?
Right.
They can't actively proselytize.
Right. And even though this hasn't gotten to the Supreme Court yet, or, might never, we've had a number of very interesting cases in the last few years that have hit the Supreme Court that the Supreme Court has ruled on with respect to religion and schools.
Yeah.
And it has kind of taken a very interesting stance, whereas, for a long time, the Establishment Clause, and correct me if I'm wrong, was more of the governing principle behind the decisions that the courts would make.
Right.
And now it has kind of shifted more towards the free exercise
Yeah.
clause. Is that a fair way to put it?
Yeah, in recent decisions, we see kind of an elevation of the free exercise clause over the Establishment Clause. And this decision to authorize a religious charter school seems to kind of take that to its logical conclusion.
Wow.
Yeah, so I'll be interested to see how this plays out. But this is another one of those implications that we talked about when we were talking about Peltier in our first episode.
Yeah.
About if these aren't public schools, that means the Establishment Clause wouldn't apply. And so it wouldn't be an issue. It could be an issue under the state constitution, but not under the U.S. Constitution.
All right. So thanks for that bell ringer, Chris. Let's jump right in. You said you've got a lot to say about Mahanoy. So let's start talking about this case.
Let's do it. I'm excited.
Okay. So this case was decided very recently, 2021. You may have heard about this in the news. This was a case of a freshman in high school going onto Snapchat and using a lot of profanity to complain about school and cheerleading and things like that. And she was disciplined by the school, and it happened off campus when she made the post. She was disciplined by the school, and her name was Brandy Levy. And she and her father, Larry, sued the school district over that punishment, stating that her First Amendment free speech rights were violated.
Yeah. And I'll tell you two of the reasons I love this case so much. One, it's the first time that a student wins at the United States Supreme Court on a speech case since 1969. So that's kind of a big deal.
Really? This is the first one since 1969?
Yeah. Students have not won speech cases at the Supreme Court since Tinker. There's been a handful of them since then, and this is the first time a student wins a speech case.
In more than 50 years. Wow.
Yeah. And the other thing, and this is just too much fun, you had to explain to 9 Supreme Court justices what Snapchat was.
Yeah, this is a big, big case, not only for the reasons that Chris just mentioned, but, it's got some big implications for schools. And this is something that I know so many administrators have been wrestling with for years, is how do we deal with social media and students saying things on social media and off campus, right?
Right.
And there have been a lot of cases that have worked their way through the system. But this was one of the few that hit the Supreme Court that was dealing specifically with off-campus social media speech.
Right. And the Supreme Court had been reluctant to kind of take on cases that dealt with it just because they're so complicated from a constitutional perspective.
Right.
The Supreme Court had opportunities for decades to take up these cases. So one of the first ones was JS versus Blue Mountain. And that was a case from 2007 out of the Third Circuit that involved a MySpace page. So taking you back, right?
Yeah. Everybody's friend, Tom. You know what the sad thing is, Chris? There's probably administrators listening to this podcast who are like, I don't remember what MySpace was. I'm too young for it.
Oh my God, don't say that. But yeah, so all that to say is this issue of regulating off-campus student speech has been percolating forever. There'd been kind of a consensus in the lower courts about how to handle it based on prior Supreme Court cases. So this is the first time that the Supreme Court, addresses this after Brandy Levy sends her lovely Snapchats from the local Cocoa Hut.
Yeah, right. Yeah, let's dig into the facts of this case here. So we've got a freshman in high school. Her name is Brandy Levy. She was a freshman in the 2016-2017 school year. And towards the end of that school year, she found out that she didn't make the varsity cheerleading team for the following school year, and she was assigned to the JV squad instead. And
That's a big deal.
yeah,
Right? For a freshman.
yeah, no, totally. And I think, like there were other rising freshmen, or may have been one other rising incoming freshman that made the varsity team and, probably fueled that frustration.
Right. Feeling like you got overlooked or someone leapfrogged you.
Right. So, by the way, Mahanoy Area School District is in Pennsylvania. So just to give a little bit of geographic context there.
Sure. One thing I love about this case, though, is other than, the local cocoa hut, this fact pattern plays out every day, everywhere in the country, right? Like
completely. Yeah. This is, what we're about to tell you, what we're in the process of telling you is, man, it's so common, right?
Mm-hmm.
So anyway, she had to try out. If she makes a team, she's required to sign a code of conduct that requires team members to, to be respectful of their teammates and their coaches and their school. Like these are very common things, right? And I'm really looking forward, Chris, to talking to you about the repercussions of these kinds of things later on in the episode. But
for sure. Yeah, not to date us again, but this makes me think of the movie Dazed and Confused, right?
Okay, that one I've seen, yeah.
Yeah.
Anyway, she didn't make the team. Okay, so she gets on JV instead, and she is really, really upset about it.
Mm-hmm.
So what happened was she goes, like you said, she goes to this convenience store called the Cocoa Hut in downtown Mahanoy City. Kids would often go there to hang out, whatever. So Brandy Levy gets out her smartphone. She took a selfie with a friend of hers, I guess, with their middle fingers raised, and she posted that selfie to Snapchat. And I think for the sake of time, we're not going to explain what Snapchat is like they had to do to the Supreme Court justices.
Yeah.
It's a social media platform. You can post something to your friends and it gets automatically deleted after a certain amount of time, right? Anyway, she takes this selfie with her middle finger raised. She posted it to her Snapchat account and she added text to the picture. And again, we're going to keep our clean podcast rating, so we're not going to say what she actually typed out, but you get the picture here. The text said, F school, F softball, F cheer, F everything.
Eloquent, to the point, concise.
Yeah, exactly. And she sent a follow-up Snapchat message expressing her frustration about being kept on the JV squad, and how she thought she was being treated unfairly. That Snapchat message was sent out to about 250 friends, many of whom were fellow students.
Right. And it was on her story, which, to talk about how Snapchat works, disappears after 24 hours? So
yeah, I think
this is
a
temporary post.
Yeah, exactly. But that doesn't prevent somebody who receives that Snapchat message from taking a screenshot of it, and then it has been saved for posterity, right?
Yeah. Another thing that I love about this case is that second message included an upside down smiley face emoji, which is mentioned in the court's majority opinion, which is the first and only time that the word emoji has ever appeared in a Supreme Court opinion.
It's a new era, Chris. Yeah. So anyway, one of the screenshots that was taken of that post happened to be taken by the daughter of one of the coaches. And so the screenshot by the next week, it really had made its rounds circulating among the school's students, especially the cheerleading squad. And apparently the coaches were upset by this. And I guess at some point, one of the coaches pulled Brandy Levy out of class and told her that she was suspended from cheerleading for the next year as a result of that snap.
A whole year. So,
yeah,
a lot of the things that we talk about with these cases is kind of the law and how we got to those situations. But to me, the decision to suspend her for an entire year, it just seems, I don't know, it seems too much. Like, it seems like the school didn't do themselves any favors.
Well, yeah. And I guess that, there's so many court cases that we will talk about where we talk about this sort of reasonableness standard, right? The courts love to use that term. Like, did the school act in a reasonable manner, right? And so that is always one thing that you have to really think hard about as a school. Is that sort of punishment fit the crime kind of thing, right? Like, Are we imposing a punishment because we're angry and we think this is ridiculous? And, or are you working very hard to sort of step back and look at something objectively and say, what is potentially an appropriate response here? Because you've got to wonder if the school had turned around and said, listen, we don't feel this is appropriate. We're going to suspend you from one game or, something like that. And we ask that you be a little bit more mindful given this code of conduct that you have signed, blah, blah, blah. You've got to wonder if they would have even filed suit in the first place. Now, again, like we have said many times before, and we'll say many times again, the law is very fact specific. So it's probably pointless for us to speculate on that right now. But the fact is, the school suspended her from cheerleading for a year. And while the family went through the district's appeals process and they appealed that suspension to the school board upheld it. And that's when they decided to take it to court. Right?
Yeah, to your point, like, if it's not a suspension for a whole year, if she just has to write like a written apology and just say like, hey, I'm sorry if I hurt anybody's feelings, like, I don't think she files suit.
Yeah, might not.
But you can see kind of, I guess, what the school was concerned about with team morale and team cohesion, which is kind of what they ultimately try to use to justify the decision.
Right.
So Brandy, upset that she has been removed from the cheer squad for a year, files suit in federal district court based on an alleged violation of her First Amendment rights. So we're looking at the U.S. Constitution again. This is First Amendment free speech. So that's why we're in federal court. And, she asks for a temporary restraining order and a preliminary injunction, which are basically just orders that stop the school or would stop the school from carrying out her punishment. So she's basically saying, I want them to be restrained from kicking me off the team.
So they're in those situations, just to clarify, they're not asking the court to rule on the constitutionality of the claim. They're just saying, we think we've got a constitutional issue. Can you put my punishment on hold?
Exactly.
Okay.
Brandy ends up winning summary judgment in this case. So they filed a motion for summary judgment. Summary judgment just basically means that, hey, we the parties or one of the parties don't think that we need to go to trial. We think we've got enough evidence here and there's no questions about the veracity of the evidence and who to believe. We're going to file a motion and then the judge just decides the entire case. Sometimes they'll decide the entire case on this motion for summary judgment. So Brandy wins motion for summary judgment. School loses across the board. The court at the trial court level said, there's no substantial disruption here. So you didn't have enough to suspend her from the team.
So they're looking at the Tinker standard, right?
Right. And Tinker becomes a big deal when we get to the Third Circuit. So this is another one of those situations where taking a step back, kind of thinking of it through the strategy of this case, as soon as the school lost the temporary restraining order and preliminary injunction, I'm kind of surprised they didn't settle the case and just basically say like, hey, yeah, you know what? We're not going to fight this anymore.
Yeah.
Let's just lick our wounds and walk away.
Right.
But the school keeps appealing this decision. And so they appeal it to the Third Circuit after they lose at the trial court. And the Third Circuit does something really interesting that no court had done up until this point. And they say that Tinker does not apply to off-campus student speech.
Really?
Yes.
Wow.
And that is really important. So Tinker, to go back a little bit, is a 1969 Supreme Court case, the last time a student won, that involved a student, Mary Beth Tinker, and her family, who all wore black armbands in protest of the Vietnam War. And her and a few other students wore these bands to school. And the school said, if you wear those bands to school, we're going to suspend you. And Tinker wore the band to school. She got suspended. And it gets all the way up to the Supreme Court. Supreme Court says that students have a First Amendment right to speech, and that extends through the schoolhouse gate. So schools have to respect student First Amendment rights. and that schools are only permitted to silence student speech if it causes a material and substantial disruption of the learning environment or if it invades the rights of others. So that's kind of the Tinker standard that we've got from this Tinker case that's been applied to student speech in the school context. We've had carve-outs to that over the years, but that's kind of like the gold standard.
Yeah. And we're going to talk about that more later on this season. We're going to hit the Tinker case.
Oh, yeah, it's going to get its own episode.
Yeah, totally. I don't think you gave too much away there. You'll still have to tune in.
Yeah, we'll call it a teaser, right? So that's the Tinker standard. And the Third Circuit hears this case with the Cussing Cheerleader, and they say essentially that schools do not have any authority to regulate off-campus speech. And they draw a very sharp line between what constitutes on-campus speech and what constitutes off-campus speech.
Where's that line?
Well, it's really vague. Oh, well, they think it's sharp, but it's a really vague line. Because this is during the pandemic too, right?
Okay.
We're doing virtual schooling, we're doing all this stuff. So like the boundaries between what constitutes off-campus and off-campus is already really blurry.
Right.
And that's something the Supreme Court picks up on too. So Third Circuit fines for the student. So Brandy still wins, but they say that we're not going to apply Tinker. You just don't have authority, school, to regulate off-campus student speech. So therefore, Brandy had a First Amendment right to her speech here, and your punishment violated that. And I think that's why the court takes this up.
Is it because they basically said we're setting basically a new precedent here? Like a completely new, because almost every free speech case up until this point, the courts have looked at Tinker as a guide, and the Third Circuit here was basically saying Tinker's not a thing.
Right.
This has nothing to do with Tinker.
Right. Yeah. And that was a pretty radical departure because, like you said, every court who had looked at this had come up with some variation of applying Tinker to off-campus student speech, whether it was a nexus test to see if the speech was sufficiently connected to the school, whether or not there was a targeted attempt to get the speech to the school. Like there was lots of different ways to basically apply Tinker to off-campus speech that still looked at the impact and effect that the speech had on schools. And that's how most of the courts had kind of handled it. But then you get this Third Circuit that comes in with a wrecking ball that kind of says, well, you know what? We're just going to draw this, what we think is a sharp line. And if you're on one side, Tinker applies. If you're on the other side, Tinker doesn't.
And so that's why the Supreme Court took this up when they appealed, right?
I won't pretend to climb into the justice's head, but that's my theory. Just because the Supreme Court had been so reluctant to touch this issue. And as the oral arguments in this case made really clear, and even the ultimate decision, the Supreme Court struggled with this one. So we're at the United States Supreme Court. We've got our 9 justices. And this is one of those situations where it's a really complicated case. Which is why I was so surprised when this came out that it ended up being a 8-1 decision with 8 justices joining the majority opinion by Justice Breyer and 1 justice, Justice Thomas, offering a lone dissent. And there was a concurrence from Justice Alito as well that was joined by Justice Gorsuch. So we've only got 3 opinions, which a case this complicated, I was expecting 4, 5, 6 opinions because I'm amazed they were able to agree on anything, really, just because how complicated this case is and all of the different constitutional concerns that we've got.
So what are those, break down those big constitutional concerns? Like what are the big components here that complicate this?
So one way to kind of think about education is as this 3-legged stool. You've got one of the legs are students, one of the legs are parents and families, and the last leg is kind of the government or the community. And this decision implicates all 3 of those groups because on one hand, you've got students' rights. What rights do students have to express themselves?
Right.
And that's really complicated because students are often children. So now not only do we have this question about what can students say in the school context, but how are constitutional rights kind of mediated by age? So that's one line of this. On the other side, we've got parents. So parents' rights to direct the upbringing of their children. And that is a really complicated interplay between parental rights and the authority of schools. And that's kind of the last big bucket here that we've got, which is what authority do schools have to regulate student conduct? How does that kind of infringe on or interact with perhaps the rights of parents to direct the upbringing of their kids? So you can kind of imagine this as like 3 overlapping circles in a Venn diagram where the court is trying to figure out like how to balance all of these issues.
Right. Wow.
So in oral arguments, Justice Breyer says, look, I've got 2 ways that I could handle this opinion. I could write a treatise on the First Amendment, but that's going to take too much time and I can't do that. Or we can use Mahanoa as an example, don't give a bright line rule, and maybe I can get a majority of the justices to agree that Brandy wins, but we might not all agree on the reasons or the standard to apply.
Okay.
And that's ultimately what happens.
So, yeah, this is one of the reasons why it was a huge decision, but it was also not a decision that provides a massive amount of guidance for educators.
This is about as clear as mud.
Yeah. Thanks a lot, Supreme Court.
Maybe that's not fair. This is a fantastic example to draw on when deciding whether or not to regulate off-campus speech. And that is all the Supreme Court is trying to do here. They're just saying, like, look, here's what we thought about. Here's what we considered. Here's what you should consider. And Brandy's case is an example of where we drew that line in one specific situation. So rather than giving us a rule, they're basically giving us an example that we can follow. So this is kind of a guidepost, if you will, on how to handle off-campus student speech. But there are some principles in here that we can kind of tease out for what we can do moving forward.
So was the end result was basically like, listen, these were not direct threats. This was not hate speech. This wasn't, bullying. This wasn't sort of like an extreme kind of speech.
Mm-hmm.
This was just a teenager being emotional and venting frustration. Didn't even seem to be directed at anybody in particular.
Right.
And they've therefore said, like, listen, if that's what this is, you got to be careful. If we suppress this speech, then where's the line?
Right.
Like, I think one of the justices said, if we allow something like this to be punishable, then all that schools will be doing is punishing kids. Like, there will be no end to punishment.
So Justice Breyer wrote the majority opinion, and he addresses that exact point. He says, sometimes it is necessary to protect the superfluous in order to preserve the necessary.
Wow.
And so he recognizes that, like, the Snapchat, it's a freshman in high school venting about her experiences in school. We all do it. We've all done it. But he says, like, to your point, we need to protect this because protecting this ensures that we protect kind of the core, pure political speech that is at the heart of the First Amendment.
So the big question that comes into my mind as a former school administrator is there's a reason why we ask student athletes and others to sign these codes of conduct and these
behavioral contracts?
Yeah, behavioral contracts and, those kinds of things. And like, does this decision just completely make all of those contracts null and void? And if that's the case, like, how can we as schools expect a certain degree of decorum, and how can we hold students responsible for living up to a set of values, right, that we feel are important to the community?
Yeah, and that's something the Supreme Court doesn't really address. The majority opinion, at least, doesn't address that question of, are those codes of conduct still good? Like, are they still valid?
Right.
And that's because this is, they're not trying to give out hard and fast rules. They're just giving us things to think about. So the things to think about that they kind of say, essentially, students have rights in schools and they do have authority to regulate student speech, but that authority is going to be different if you're on school grounds versus if it's off school speech.
I mean, I'm wondering, like, I'm trying to think this through and apply Tinker. One of my thoughts is, I wonder if a situation like this if the school could make a kind of argument like, let's say they have a student who does something like this, it violates their code of conduct or whatever. If the school approached a situation like this by saying, listen, the behavior that you have engaged in has violated our code of conduct, and if it continues, we're going to have to remove you from the team, or we're going to have to take other actions. Because if that kind of stuff continues, the school could reasonably make an argument that if this stuff continues unchecked, it could undermine the authority of the coaches.
Right.
It could cause substantial disruption. It could jeopardize the cheer community.
Right.
And so maybe in a situation like that, the code of conduct is still valid, but one momentary lapse of judgment shouldn't result potentially in such an extreme consequence.
Right.
Right?
Yeah. And that's something like the Supreme Court doesn't look at the kind of the severity of the consequence. That came up in oral arguments a little bit.
Yeah.
But the court does address those school interests. And essentially, the school makes the argument that they have an interest in teaching good manners and civility. And that's something that the Supreme Court has recognized in prior cases.
Did they ignore it in this case?
No, in this case, they said that there's a distinction between on-campus and off-campus, and that off-campus, you've got these other concerns about parental rights that aren't at play when students are at school. And you've also got this question about like, sure, you can teach good manners and civility, but where's the line? How do we differentiate between teaching good manners and silencing students? Because if schools can regulate off-campus speech, then students are under regulation 24/7. Everything they say and do could be punished by the school. And the court was really worried about drawing that line in too overbearing of a way.
Okay.
Yeah. So the Supreme Court gives us, I like to think of this as kind of a red light, green light, yellow light situation, where, they give us some red lights, like don't punish someone in Brandy Levy's situation. They give us some green lights too. So this is when the Supreme Court says, hey, schools may have authority to regulate off-campus student speech if it falls into one of these categories. So quoting from the opinion, they say that several types of off-campus behavior that may call for school regulation includes serious or severe bullying or harassment targeted at particular individuals. So that goes back to your point, like Brandy's comment wasn't targeted at anybody. It was targeted at the school, but not at individuals.
Right. Okay.
Threats aimed at teachers or other students, the failure to follow rules concerning lessons, the writing of papers, the use of computers, or participation in other online school activities, and breaches of school security devices, including material maintained within school computers. So that last bucket is basically like cheating or, academic misconduct kind of issues.
Okay.
And those are kind of the three green lights that the Supreme Court gives us for when it's more likely to be okay to regulate students' off-campus speech.
Got it.
And what's interesting here is the Supreme Court doesn't apply Tinker. Like, they don't say, we're applying a version of the Tinker test, but they still worry about disruption. And all of these considerations are things that are kind of like targeted at the school. So again, these are situations where we might have a better likelihood of that substantial disruption that Tinker looks for, even though the court doesn't, say we're applying Tinker. So we got our red light, those are our green lights, and then we've got the yellow lights. Well, this is where lawyers make their money. So we've got our yellow lights, and essentially the court gives us some considerations that we need to think about.
When you say yellow light, like, are you thinking about yellow light in terms of like, hey, everybody, let's slow down and be a little cautious? Or are you thinking about like, let's throw caution to the wind and speed right through?
I'm thinking about the let's apply caution.
It's a yield sign.
Yeah, the principle of the yellow light rather than perhaps the reality of the yellow light. Yeah, so they give us these three considerations. First is that schools, when we're dealing with off-campus speech, are rarely going to stand in loco parentis. And this phrase, in loco parentis, is really important to both the majority opinion and to Justice Alito's concurrence. So in loco parentis is...
It's in place of parents, right?
Exactly. Yeah, see, look.
That one I know.
Yeah. And I think we pronounced it right. Hey, look at us. So in loco parentis comes from Sir William Blackstone's commentary on English law. Let's see, I think it's 1765. So Sir Billy Blackstone publishes this really influential book about commentaries on the laws of England. And in loco parentis is a phrase that he used to basically say that tutors or schoolmasters, when a parent delegates part of their parental authority, that the schoolmaster can use restraint and correction as may be necessary to accomplish the goals for which they're employed. So this idea dates back centuries, right? But the Supreme Court in Mahanoy says when students are off campus, in loco parentis doesn't really apply. Because
the kid isn't in your charge.
Exactly. There's a big question about whether or not in loco parentis is still let's call it a valid justification for school authority in this age of compulsory public education, which is something Justice Thomas picks up in his dissent. And he kind of even acknowledges, which was surprising, that like, hey, things have changed in 200 years. Maybe we should rethink this rule. which was a little surprising for Justice Thomas, given his dissent in some other cases involving student speech, where he kind of just said, students historically not had free speech rights, and therefore they still don't have free speech rights. So that's kind of the first consideration they give us within these yellow lights.
Okay.
The second consideration is looking at that issue of line drawing. So if we allow schools to regulate off-campus speech, then everything a student utters 24/7 is going to be subject to regulation. And they're really skeptical about that because it's just going to have such this heavy burden, this chilling effect. So they're going to be really hesitant to allow schools too much authority here. And then the last one that they give us for this yellow light is this idea that schools themselves have an interest in protecting student speech. So typically we think about the school's interest in regulating student speech, but here the Supreme Court says, no. You schools have a countervailing interest here. You are the nurseries of democracy. You have an interest in protecting and promoting students' expression so that they can grow up to be these engaged, responsible citizens. And so all of those three things kind of mediate against regulating off-campus student speech.
I mean, listen, and I think, to that second point, on one hand, schools could look to this decision and be like, well, this doesn't give us the ability to maintain order and control in a way that we had hoped. On the other hand, you could look at this almost like a relief. Like, because if we had that control and we had to exercise that control, that's all we would be doing.
Right.
Right? We wouldn't be doing anything else.
There'd be pressure to do it, yeah.
Yeah. And the court has basically said, like, if the speech is bad enough, in terms of bullying or threats or whatever,
right,
we can step in. So if there are things that are going to be major problems for the school, we have the ability to step in.
Right.
Or at least they haven't closed that path.
Exactly. Yeah, I liked what you said. Like, in a way, this kind of takes some of the responsibility. Yeah, exactly. We're like, hey, kids are going to be kids. Our job is the educational mission, and we'll address student speech if it disrupts the educational mission, whether it's on campus or off campus, but it's got to rise to a very significant level. Yeah, so in a way, like, I can imagine kind of breathing a sigh of relief, like, oh, hey, that's one less thing I have to worry about.
Right.
Yeah. And that's something that Justice Alito says in his concurring opinion. So Alito joins the majority opinion in full, and then he writes separately just to kind of explain how he would have done it if he had written the majority opinion or if, he was the dominant voice. And he basically says that there's this idea of implied consent where parents who send their kids to public school implicitly consent to having their rights diminished. And that in order to kind of figure out where the line is, we look at whether or not it could be reasonably understood that somebody would consent to their child relinquishing those rights as a trade-off for attending public school.
Okay.
And ultimately, he kind of says that line, where we draw that line, is really going to be in favor of students. So he kind of sums up the majority of decisions, kind of guiding principle, and he says, at the end of his concurrence, if today's decision teaches any lesson, it must be that the regulation of many types of off-campus student speech raises serious First Amendment concerns, and school officials should proceed cautiously before venturing into this territory. And I think that's a good takeaway, a good punchline from this. Is just proceed carefully.
Yeah. It's a fascinating case. I mean, for all the reasons we've mentioned before about how this is the first one that the Supreme Court has taken up, it's the first one that a student has won in over 50 years.
Mm-hmm.
And it does, while it might not provide the definitive goalposts and give schools definitive authority over certain kinds of off-campus behavior, it still does provide interesting insight and guidance and things to think about.
For sure.
Right? In these kinds of situations, and I can say, just in doing a little bit of searching, like there are already a number of cases that have either been ruled on or are in the system that are now referencing the Mahanoy decision.
Right.
And the rulings are going kind of either way, depending on the kind of off-campus social media speech that was the subject of those particular cases. Right.
And that's the nature of kind of how the court decided this case is they gave this as an example. And if they give examples, that means some are going to fall on one side of this example and some are going to fall on the other side of this example. And so it's going to take a lot more cases to kind of solidify that line.
Right.
Which is what we're seeing, but it definitely gave us guidance. And I think, to your point, it kind of relieved some of the responsibility for this from school administrators. That's to say, though, this dealt with the school's authority to punish someone for their speech. It didn't address how schools can handle this in other ways. So in First Amendment law, one of the things that is often said is the remedy for speech you don't like is speech you do. So the remedy for speech is more speech, which is another way that the school could handle something like this, where like you've got a student saying things on social media. Maybe you don't punish them. Maybe you use it as a teaching moment or something like that, which is, maybe what the school could have done in Brandy's case. There's lots of options here that don't go to that kind of blunt punishment that are still completely on the table.
Yeah. And listen, if you, work at or run a school that has dealt with this kind of stuff before and you have policies and procedures that are in place regarding these kinds of issues that you think are really effective and really interesting and obviously don't run afoul of the Supreme Court decision, don't hesitate to share those with us because we would love to look into them and share them with others. It's a really interesting case. And, to your point that you made a few minutes ago, we see this over and over and over again with the courts is the court will, every now and then there's some sort of big case that comes along, right? And sort of carves a little bit of a new path, but it's not an incredibly defined path yet, right?
Right.
Because subsequent cases will come along and further provide guidelines and parameters and goalposts around that particular issue. So, Tinker, right, was one of the first ones. And then other cases came along in subsequent years, like Morse versus Frederick and Bethel versus Frazier, right? That said, okay, let's look at Tinker, but let's also consider some of these other facts, right? That Tinker didn't really address.
Yeah. Hey, those all sound like good subjects for future episodes.
Let's do them. Because some of those cases are really fun and interesting.
Oh, yeah.
Yeah. So we're closing in on time here. Anything else that's important to add?
So the last thing I'll say is just a little bit more about Justice Thomas's dissent.
Okay.
So Justice Thomas is really focused on historical practice here. And so he makes the argument essentially that 150 years of history support the decision to suspend Brandy Levy here.
Really?
Because he looks at all these historical cases where schools essentially have the authority, according to Justice Thomas, to regulate speech even when it occurs off campus, so long as it has a proximate tendency to harm the school, its faculty or students, or its program. And that's not that dissimilar to the line the majority draws. Justice Thomas just kind of would defer a little bit more to the school's conclusion about what has a tendency to harm or, the significance of that harm. And, he cites this case, Lander versus Seaver from 1859. So just kind of looking at this historical perspective, right?
Taking it old school.
Funny you say that. So this is a Supreme Court of Vermont case. And it involves a student who is walking home from taking the farm animals out to pasture. He's herding some cows past the teacher's house. And the teacher, Seaver, is in the front yard doing some work or whatever. And the student says, "There's old Jack Seaver." And the teacher apparently did not like that because he didn't think that was respectful. And so the next day in school, he takes the switch and kind of, wraps him over the backside a couple times. And the student sued and basically said like, "Hey, you shouldn't have done that." And the court sides with the teacher and basically says like, "Hey, they've got authority to discipline students in a reasonable way. This wasn't excessive."
And that's the case he's citing?
And that's the case Justice Thomas is citing. And, that's not the only one. He's also looking at kind of the that's just an example of a general trend that he identifies. But he does recognize, to his credit, that there might be good constitutional reasons to depart from that historical rule, but the court didn't address it. So I'm not going to worry about it either, is kind of what he says.
Yeah.
Interesting arguments at the Supreme Court.
Yeah. Wow.
Maybe we should do the old Jack Seaver case. Do you think it's relevant to do an 1859 case?
I mean, it's literally old school, but we'll look into it, see if we can do it. Okay, so that just about does it for us today. We hope that you have enjoyed this little dive into online student speech. And I'm going to kick it over to Chris to talk a little bit about what your homework is.
All right. So, homework. Like and subscribe. You can find Chalk and Gavel wherever you find your podcasts. If you could subscribe and write a review for us, we would greatly appreciate it. That helps us spread the word on all of these different podcasting platforms. So please, if you like what you hear, go ahead and do that. Check out our upcoming episode list. You can find it online at chalkandgavel.com. There's also a form there for you to fill out if you have any questions or things that you want us to cover in future episodes. We'd love to hear your thoughts and your feedback. You can do the same thing on social media. You can find us at Chalk and Gavel. Let us know your questions, comments. Love to continue the conversation.
And that does it for this episode of Chalk and Gavel. Thank you for listening.
I'm Chris Thomas.
And I am Jamie Cudlitz.
Join us in 2 weeks where we continue to explore how the courtroom is connected to the classroom with a case involving a transgender student name policy. Very pressing issue that should lead to some very fun conversation. That is the case we're doing next week, right?
Yes, that is the case. See you then.
So the kids all